So, meine Damen und Herren, ich eröffne die 122. Sitzung des ersten Untersuchungsausschusses der 18.
Good morning. I'd like to open the 122nd meeting of the First Committee of Inquiry of this electoral term. The public has been established and media and press representatives and the public are welcome. The translation is working, yes? Could you nod to the chair? Yes, good.
So, ich sag jetzt mal was. Hören Sie die...
Okay, you hear the translation. Could you...
Beide können die Übersetzung
yes.
hören. Gut,
all right.
Dann seien auch Sie ganz herzlich nochmal
begrüßt. Well, welcome to you as well.
Zum eigentlichen Gegenstand der heutigen Sitzung
Before we speak about the subject matter of this meeting, please allow me some introductory remarks. There will be no audio or video recording during this meeting. Due to the great public interest, the committee decided, as an exception and in accordance with the law of the Committee of Inquiry, to allow videotaping of this meeting by the German Bundestag's administration, and this will be broadcast live on the parliamentary channel of the German Bundestag. According to Section 13 of the Committee of Inquiry Act, the experts have to agree as well as the majority of the members present. So this is decided. We will have a vote on this decision right now. Who's in favor? Thank you. No. No one opposing, no one in abstention, so this is decided. Any additional audio-video taping is not allowed. Please switch off all your devices, and should you violate this stipulation, you may be excluded permanently from the meetings of this committee and the entire House. It can also have consequences under criminal law. So please take note of this stipulation, because you can watch it live on the parliamentary channel. In this meeting, we will publicly take evidence based on the decision to take evidence SV 17. We will take evidence on the subject under investigation, Bundestag printed matter 18843 and 1886-83, by hearing expert witnesses from the United Kingdom. This hearing will be an open hearing. This hearing will be interrupted at around 10 after 10 for a roll call vote. This is mandatory because all members of the committee have to leave this room and have to attend the voting procedure. We will return immediately and continue with this meeting. I would now like to welcome our expert witnesses in alphabetical order. First of all, Eric King, director of the NGO Don't Spy on Us, and Ms. Caroline Wilson Palow, general counsel with the NGO Privacy International. Warm welcome to both of you. Good to have you here. Wilson Palow, Mr. King, thank you very much for following our invitation and for being willing to make this journey or to speak here to us as expert witnesses. This is the only parliamentary committee of inquiry dealing with this issue, with the Snowden disclosures. So I'm very pleased that you're giving us the opportunity to get a clearer overview, which is not just a retrospective work, but we also look into the future, think about possible recommendations in our final report. There is a part with the recommendations, so it is a particular pleasure that you might give us any hints regarding the future, what could be done better. The situation in the United Kingdom has already been the subject of another hearing that took place on December 1st of this year, where we also had experts from the UK, so your presence here today will give us the opportunity to further deepen these insights. I have to point out to you that the Bundestag administration will not only do a live streaming on parliamentary channel, but we will also make an audio recording. This is only used in order to facilitate the stenographic record of this meeting, and the recording will be deleted subsequently. The minutes of this meeting will be forwarded to you, and if necessary, you have 2 weeks for any corrections or amendments. Do you have any questions so far? Thank you. You were also given the opportunity to submit a written statement should you have done so, this will also be published on the website of the committee. So Wilson Palow, Mr. King, before you give evidence, I'm obliged to caution you. You have been summoned as expert witnesses, and as expert witnesses, you are bound to tell the truth. Your testimony must be impartial and given to the best of your knowledge and belief. I also have to caution you against the possible consequences under criminal law should you fail to tell the truth. Under sections 162 and 153 of the German Criminal Code, whoever gives false unsworn testimony before a committee of inquiry shall be liable to imprisonment from 3 months to 5 years or a fine. Under sections 28 and 22, paragraph 2 of the Committee of Inquiry Act, you may, however, refuse to provide information in response to questions if answering those questions would expose you or persons related to you within the meaning of section 52(1) of the German Code of Criminal Procedure to the risk of investigation under due process of law. This refers to investigations due to criminal offenses and administrative offenses, in case this applies to you, as well as disciplinary proceedings. In these cases, you could refuse to answer. Have you any questions so far? Thank you. After this introduction, let me briefly explain the planned procedure of this hearing. According to sections 28 and 24(4) of the Committee of Inquiry Act, you will be given the opportunity to speak in context on the matter under investigation. The order will take place in alphabetical order, or that is the order in which you are seated. And please stick to a time frame of 10 minutes each for your introductory statement. After that, the 4 parliamentary groups will be given the opportunity to ask questions, and each member can address 1 question to both of you or 2 questions to one of you. After the first round of answers, we will have another round of questions so that every parliamentary group will be given sufficient time to ask questions, and you will be given sufficient time to answer. This is the common procedure for hearings like this, and we will try to finish around 10:50 because we have an advisory meeting, a consulting meeting at 11 o'clock, and after that we will hear other witnesses, which will not start around 11:30, but probably around 12 or 12:30. What is important for you is that we will finish this part of our hearing around 10:50. Have any questions? Perfect, thank you. Based on the decision to take evidence for this hearing, SV 17, we speak about the parliamentary, public and scientific debate in the United Kingdom on the activities of UK intelligence services in the field of SIGINT, the parliamentary oversight, as well as the protection of privacy, in particular with possible changes to the legal situation following the Snowden disclosures. Also, the legitimization for the services and possible protection for the gathering and collecting, processing and forwarding of telecommunication data and the scientific institutions in the UK related to this. We already heard 4 expert witnesses on the 1st of December, Professor Richard Aldrich from the University of Warwick, the Independent Review of Terrorism Legislation, David Anderson, Silky Carler from the NGO Liberty, and Counsellor Ben Jeffrey. I'm sure you know these people. Many interesting issues were raised during that hearing, and together with you, we would like to further deepen these issues. Ms. Wilson Palow, Mr. King, we hope that you can shed some light on some of the issues, and I would like to ask you now to give your introductory statements. We will start in alphabetical order. So, Mr. King, the floor is yours. Thank you. And 10 minutes, please. All right. Please, go ahead. Thank you.
Hello, good morning. I wish to thank the Committee of Inquiry for giving me this opportunity to testify. My work is focused around human rights and signals intelligence. For the last year, as you noted, I have acted as director of the Don't Spy on Us coalition of UK NGOs working around the reform of surveillance laws in the UK. Prior to that, I was Deputy Director at Privacy International. It's important to note I don't represent either of those entities today and instead appear in my own capacity as an independent expert. As was mentioned, I understand the committee has received evidence on the recent changes to UK surveillance law with the passing of the Investigatory Powers Act 2016. I also understand the committee has heard from witnesses on the state of UK-based litigation from parties, including Privacy International. I don't wish to duplicate that evidence. Instead, I have noted an interest on behalf of the committee regarding the so-called No Spy Pact that exists within the Five Eyes Alliance and other partnerships. So we'll use this introductory opportunity to set out a very brief summary of the conclusions of my work in this area. So in 1946, there was the alliance of 5 countries, the US, UK, Australia, Canada, and New Zealand, also known as second parties, developed a series of bilateral arrangements over more than a decade that became known as the UQSA arrangement, establishing the Five Eyes for the purpose of sharing intelligence, primarily signals intelligence. The UQSA intelligence arrangement is believed to have created a no spy pact between its parties. This is a fact that's often reported. The existence of such a pact implies that the parties to the agreement have an obligation to refrain from collecting signals intelligence on each other's citizens. However, within the original text of the UQSA arrangement, which was declassified and publicly released in 2010, there is no such clause that attempts to create such an express obligation. Documents released by Edward Snowden provide some of the only insight into how these original terms have been interpreted by the various parties and applied to modern-day practices. It seems there is instead a general understanding that citizens will not be directly targeted. Where the communications are incidentally intercepted, there will be an effort to minimize the use and analysis thereof by the intercepting state. A leaked copy of the US National Security Agency Directive on collection, processing, dissemination of allied communications states that under the UQSA arrangement, both governments agree to exchange communications intelligence, products, methods, techniques as applicable so long as it was not prejudicial to national interests. This agreement has evolved to include a common understanding that both governments will not target each other's citizens or persons. The head of the New Zealand intelligence service, the GCSB, has said in public that he also views the arrangement as providing a similar set of protections. He stated publicly, "You cannot read the UQSA arrangement without coming to the conclusion that the full sharing, which is described, can only be done if there's no deliberate targeting against each other's governments or nationals." It is assumed, but not known, that the other parties to the Five Eyes arrangement, Canada and Australia, view the arrangement in the same light. Numerous documents disclosed as part of the Snowden revelations show that this underlying agreement manifests itself not just in policy documents, but the underlying technical architecture of the actual SIGINT collection systems themselves. So even with these bulk interception systems, there are technical rules that are put in place by all parties that minimize metadata and content from IP addresses known to be in UQSA countries. However, this general understanding does not prevent Five Eyes states from targeting each other's nationals or collaborating to analyze information about their own citizens collected by a second party on a bulk scale. When a Five Eyes partner wants to target the citizens of another country, they first attempt to do so with the other country's consent. It is unclear on what basis this consent may be given or withheld, but the same directive referenced earlier explains there are circumstances when targeting of second-party persons and communication systems with the full knowledge and cooperation of one or more second parties is allowed when it's in the best interests of both nations. The directive goes on to make clear that these circumstances may include targeting a UK citizen located in London using a British telephone system, targeting a UK person located in London using an internet service provider in France, or targeting a Pakistani person located in the UK using a UK internet service provider. These leaked GCHQ documents also show that additional authorization is needed by British intelligence services should they wish to target the citizens of a Five Eyes countries. This importantly applies no matter where that citizen is in the world. There have also been instances where Five Eyes states have consented to other parties in the Five Eyes alliance making use of material intercepted under bulk intercept programs related to their own citizens. Previous practice across the Five Eyes would require that minimization or the immediate deletion of such incidentally collected material was a requirement to comply with UCUSA. Such a practice could mean removing the names of identifiable UCUSA citizens from finalized intelligence reports, or when conducting analysis of large data sets that include UCUSA citizens, placing personally identifiable information, replacing it, with a hash or a pseudonymous tag related to them. Then, in such individual cases, permission could then be sought by the relevant government to seek to unminimize such material. But this policy and practice that has existed for a long time is appearing to be relaxed in some areas. One example of this is a UK change in policy in 2007 to permit the NSA to unminimize all incidentally collected UK contact identifiers, including IP and email addresses, fax and cell phone numbers, for use in analysis. Given the reported extraordinary scale of NSA collection, this change in policy means that for many UK citizens, their communications are being intercepted by the NSA, and the NSA has had express permission to analyse them, even identifying those UK citizens within it. This policy essentially permits the analysis of information relating to UK citizens by allied countries, which information the UK intelligence agency would not themselves be permitted to analyse without additional authorisations. The NSA could then share that information derived from the analysed communications with foreign and potentially British intelligence agencies, potentially circumventing UK authorisation procedures. As all policy relating to intelligence exchange in the UK is subjected to a neither confirm or deny policy, this change in policy has not been officially acknowledged by the government. There's no reason given or further detail provided as to why the UK permitted such a radical change in policy. While there is a preference and understanding that Five Eyes governments will not target each other's citizens, if consent isn't provided, then states do reserve the right to act unilaterally. The directive I've mentioned already states, when it's in the best interest of each other's nations, each reserve the right to conduct unilateral comment, the collection of signals intelligence, against each other's citizens and persons. Therefore, under certain circumstances, it may be advisable and allowable to target second-party persons and second-party communication systems unilaterally when it's in the best interests of the US and necessary for US security. For this reason, any suggestion that the UCUSA arrangement, this Five Eyes arrangement, creates a no-spy pact could be seen as misleading. Certainly, the arrangement makes it clear that there's no absolute prohibition on the targeting of Five Eyes allied parties. It's perhaps for this reason that President Obama felt able to state, there is no country where we have a no-spy arrangement. And former NSA Director Michael Hayden supported this statement, explaining, no, we're not going to do no-spy arrangements. It's just too hard to do, not even with the British. Outside these Five Eyes states, there are other countries that have agreed to the exchange of intelligence known as third parties. This, of course, includes Germany, which is a third party to the UCUSA arrangement. There are 41 such third parties. In Europe alone, there are 23 such third-party countries. Of these, 14 countries have formed a group called SIGINT Seniors Europe. Beyond the existence of the group, there's very little known about the exchange between these parties or whether any attempt has been made to provide for similar protections for each other's citizens as exists between the second parties of the UCUSA arrangement. However, there should be no ambiguity about the policy regarding the targeting of third-party countries like Germany by second parties. An internal NSA presentation makes clear we can, and often do, target the signals of most third-party foreign partners. So, in conclusion, the UCUSA arrangement does not, in my view, amount to a no-spy pact. It does, however, in practice, afford some greater safeguards to those Five Eyes citizens who would otherwise be afforded none. My view is that a better way of achieving this same goal is to respect the privacy rights of every individual, no matter where in the world they may be, and furnish them with the same statutory protections that a country's own citizens are entitled to. This needn't be constrained just to the Five Eyes countries. Indeed, I would encourage all states to provide such protections and encourage other states to do the same. I'd be pleased to answer any questions on this aspect of my evidence or any other related areas that I'm able to assist the committee. Thank you.
Ganz herzlichen Dank. Ich warte mal, bis die Übersetzung auch gelaufen ist. Danke ganz herzlich und dann...
Thank you very much. I'd like to move on to the second statement. Thank you for being with us, Ms. Wilson Palow. The floor is yours. 10 minutes, please.
Thank you. And thank you to the committee for inviting me here today. I am the General Counsel of Privacy International, a charity based in London, which is dedicated to defending the right to privacy around the world. As General Counsel, I lead PI's legal team, and I'm representing Privacy International here today. You have asked us to speak about the changes that have taken place in the parliamentary, public, and academic spheres since the revelations made by Edward Snowden on issues concerning the activities of the UK intelligence services, including any parliamentary oversight of these activities and, of course, the protection of privacy. I started at Privacy International in 2013. Shortly before we all learned about the Snowden revelations, which has given me a front row seat to how they've affected the debate in the UK. So I'm going to begin today with a short story about my own experiences with the evolving nature of transparency and oversight in the UK regarding the activities of the UK intelligence services. While there have been some improvements on both fronts, from a human rights perspective, there's still much work to be done. Along the way, I've experienced some of the same frustrations that I understand this committee has at times experienced when faced with sometimes the extremely strong reluctance of the United Kingdom to discuss the activities of its intelligence services so that there could be a public debate around those activities. At times, it has taken significant effort to overcome this reluctance. And even today, as admittedly much more has gone into the public domain during the debate surrounding the Investigatory Powers Act, much is still shrouded in secrecy in a way that I think has hindered the public debate and a full understanding of the surveillance power is now enshrined in that act. The initial reaction to the Snowden revelations in the UK was mixed. Several of the earliest news stories implicated the UK intelligence services, both as receiving intelligence from the US that was gathered under what was identified at the time as the PRISM program, and also as collecting vast amounts of data themselves through programs like Tempora, which was the mass interception of communications traveling under undersea fiber optic cables. The initial reaction of the UK government, despite significant public attention at the time, was to rely on its neither confirm nor deny policy, under which it refused to admit whether the programs referenced in the Snowden documents, even at the most abstract level, were actually being undertaken by the UK intelligence services. The hand of the UK government was forced somewhat when the US government admitted that PRISM was in fact a real program being undertaken by the NSA, and that information obtained under PRISM was being shared with the UK. After this admission, the UK Parliamentary Oversight Committee, the Intelligence and Security Committee, which oversees the intelligence services, released a short report in July 2013 stating that while the UK had received intelligence from the US obtained via the PRISM program, that sharing was entirely lawful and been properly authorized under the laws currently in place, including the Intelligence Services Act of 1994 and the Regulations of Investigatory Powers Act 2000. This conclusion would come back to haunt the ISC when in February 2015, in response to a lawsuit filed by Privacy International, Liberty, Amnesty International, and 7 other NGOs, the UK Investigatory Powers Tribunal, which also oversees the activities in the intelligence services, ruled that the sharing of information between the US and the UK had been unlawful prior to December 2014 due to a lack of publicly accessible legal framework governing that sharing. This lawsuit was the first in a series filed by Privacy International and other NGOs in the UK challenging the activities of the intelligence services. As you have already heard from experts who appeared before this committee before, including Ms. Carlo and Mr. Jaffe, these lawsuits that were filed between July 2013 and June 2015 addressed the following types of surveillance: bulk interception of content and metadata, which is often referred to as communications data in the UK, intelligence sharing between the US and the UK, targeted and bulk hacking by the UK intelligence services, the collection of bulk personal data sets, which are large sets of information that can contain personally identifiable information, and the obtaining of communications data in bulk. The Snowden revelations provided some of the foundation for these lawsuits. While these lawsuits were proceeding, and we suspect in some cases as a result of the lawsuits, the UK began to slowly release more information about the activities of the intelligence services. For instance, in February 2015, on the same day in which the UK government was to respond to the lawsuit on hacking, they released a draft code of practice on what they call equipment interference, which encompasses hacking by the intelligence services. While far from perfect, that draft code was one of the first glimpses into the way the UK was establishing policies and potentially safeguards surrounding this type of surveillance activity. As you've already heard, over the next few months in 2015, a series of reports were released regarding the intelligence services activities, including by the ISC, the Parliamentary Committee, by the Independent Reviewer of Terrorism Legislation, Mr. David Anderson, from whom you've heard, and by the Royal United Services Institute. Those reports provided additional insight into some of the surveillance capabilities being exercised and revealed, including revealing one new type of surveillance, that of the collection of the bulk personal data sets that I already mentioned. The reports uniformly criticized the confusing and outdated legal regime governing surveillance powers of the UK intelligence agencies at the time and recommended reform. The UK government's response was to publish the Draft Investigatory Powers Bill in November 2015. The bill, which is now an act, was a step forward in transparency because it included explicit references to and rules governing certain surveillance powers, such as hacking and the collection of bulk personal data sets, that up until that point were being authorized under a very old and vague set of laws that we argued, and in some cases the IPT agreed, were so broad as to fail to provide the necessary transparency and foreseeability required in order to intrude upon privacy. When it published the bill, the government also admitted for the first time it had been using another very old and vague power, Section 94 of the Telecommunications Act of 1984, to obtain bulk communications data about people within the UK. This is the same practice that was rather roundly criticized in the US following the very first Snowden disclosure of the famous Verizon order, in which led the US Congress to rein in the practice under the USA Freedom Act. The IPT has since agreed with us that the use of Section 94 for the bulk collection of communications data was in fact a violation of Article 8 of the European Convention on Human Rights. Yet the practice of collecting communications data in bulk will continue in the UK because it's now explicitly permitted under the Investigatory Powers Act. And that, from our perspective, has been one of the major flaws with the Act and the debate surrounding it. While transparency has undeniably been increased over the last few years, transparency is not the sole criteria for a human rights compliant surveillance regime. We disagree that merely enshrining bulk surveillance in the Act makes bulk surveillance legal. There's long-standing precedent under UK law and under the European Convention on Human Rights that requires that any interference with privacy, among other things, be based on reasonable suspicion. This is lacking from both the bulk powers provisions of the bill and the so-called thematic warrants, which I think you've heard about before, which authorize large scale collection under the targeted powers of interception and hacking contained in the bill. The question of whether bulk surveillance is proportionate was also never fully tackled during the UK debate. While, as you've heard, David Anderson published a report earlier this year concluding that some of the bulk powers had, in his opinion, been shown to be useful, he did not tackle the more nuanced question of proportionality, which is whether, even if the powers are useful, does that usefulness outweigh the significant intrusion into privacy that they cause and the potential threat to a democratic society caused by their very existence. There is also an open question as to whether admitting to the broad powers without tackling the more specific implementations of those powers has sufficiently given the public a full understanding of what can be undertaken now by the UK intelligence services, and enough to sanction those surveillance capabilities now permitted under the Investigatory Powers Bill. For instance, while the Act broadly permits bulk interception of content, we know from the Snowden documents that such interception can take a variety of forms, most of which were never explicitly addressed during the parliamentary debates because of the unwillingness of the UK government to engage at that level of detail. For instance, we do not know if the bulk interception power will be used to capture the webcam feeds of millions of people, as has allegedly happened under the optic nerve program revealed by Mr. Snowden. Nor do we know if the bulk hacking power will be used to authorize the hacking of overseas service providers, such as Google and Yahoo, as purportedly happened under the program codenamed Muscular. For all of these reasons, while I think there has been some progress in how the UK governs its intelligence services, there's still significant room for improvement. Many of the powers that now form part of the Investigatory Powers Act, including data retention, bulk interception, and hacking, are currently subject to legal challenges at the European level. It'll be interesting to see how the government reacts to those judgments, one of which I understand is expected next week, which will of course set a precedent across Europe. Thank you for inviting me here, and I'm happy to answer questions.
Ganz herzlichen Dank und wir würden dann auch jetzt...
Thank you very much for this statement, and I'd like to move on to the first round of questions. Mr. Wendt and then Ms. Renner. Let me collect questions from each of the parliamentary group, and then you will be given the chance to answer these questions. Mr. Wendt, please, from the Christian Democrats. Well, thank you, Chair. Thank you, dear experts, for being with us this morning. I have two questions to Mr. King. You mentioned the no-spy agreement of 1995, and you said it does exist, but you didn't actually focus on why it came into existence. Why is it necessary, from your point of view, that the states, or what could have been the reason why the states actually decided to conclude such a pact? It not just includes the surveillance, because it also includes, of course, the surveillance of potential terrorists or criminals, but also the surveillance of your own citizens. In Germany, it is, for example, possible to put surveillance on criminals of your own country. Just for example, maybe you could speak about this, especially in view of the threat situation. We had a topical hour in the Bundestag on the attacks in Istanbul, in Cairo, in Nigeria. More than 300 people were killed last week alone through terrorist attacks, and you know that the terrorist situation has clearly deteriorated since 1995. So that would be my first question. My second question: are there concrete cases where people were put under surveillance unlawfully? Is there like a point of contact in your NGO where people can address their concerns? How does that work? Thank you. Ms. Renner from the Left Party. Yes, I have a question to Mr. King. You mentioned the example from 2007, this what we call the circular exchange of data between the US and the UK. What do you know about such joint data transfers between the UK and Germany, UK services and the German services? And are you aware of any examples to this effect? That would be my first question. My second question to Ms. Palow. If you can give me the answer, if not, I'd like to ask Mr. King. The documents that were published in the Snowden context mention individual operations, PRISM, for example. Which of these operations, or which of the components involved, the hardware, the software, etc., have been confirmed after the activities that took place in the UK after 2013? Did you get any proof that some of these operations were actually applied and used? Thank you, Mr. Flieseck, for the Social Democrats. Thank you, Chair, and thank you for being with us. Good morning. My question relates to the cooperation between intelligence services and the legal framework governing this cooperation, especially from a UK point of view, because this is an issue that is of great interest to us, because you have national law, you can create national law for the work of your own intelligence service, which makes sure that the work is restrictive, so to speak, and that there is also the possibility of oversight. But whenever you leave the national realm and when you enter the realm of cooperation between intelligence services, then you enter in a somewhat gray area. So what about the legal framework and the framework for oversight regarding British services when it comes to determining the responsibility of cooperation between intelligence services? That would be my first question, actually to both experts, if possible. Well, then you don't have a second question, no? Okay, thank you. That's all you get. Sorry, Mr. von Notz. Okay, so how do I do it? How can I put my two questions in? No. Okay, good morning, first of all. And thank you for being with us this morning.
Ich will vielleicht mal so beginnen, inwieweit Sie auch Einblick haben in die technische
Well, I would like to know to what extent you have an insight into the technical implementation of what you described, and this is actually a question to both of you. How does it work in practical terms if there were a no-spy agreement between the individual Five Eyes members? Because you would have to apply filters, for example, attached to every data package that would identify the package as a British package, for example, just in simple technical terms. But how would that actually work during the acquisition of data, not during the processing, but during the data gathering? And do you have any idea how it is practically done between the Five Eyes states? Do they share everything? And is there one big data pool for all of the states, or does each Five Eyes have their own set data pool for storing bulk data? How does this work? Thank you. Okay, that would cover all the parliamentary groups. Ms. Wilson Palow, would you like to answer the questions? Thank you.
Yes, thank you. I'll begin with a question regarding the Snowden documents and whether or not any of the individual operations have been confirmed by the UK government. The UK government did confirm that they are receiving intelligence obtained by the NSA under the PRISM program, that is being shared. I think that is one of the only explicit confirmations from the Snowden documents of a program. And maybe Mr. King will have further insight into this. But that being said, there have been confirmations at a higher level. For instance, we understand, I mentioned the program codenamed Tempora, which is the bulk interception program. And while the UK government has never admitted to that particular code word, we do know that under the prior legal regime, the Regulation of Investigatory Powers Act, and now under the current Investigatory Powers Act, that there is a bulk interception capability available under law, and that the UK government engages in that activity, which is essentially what we understand Tempora to be. So we understand that there's bulk interception. We understand also from some of the reports that have come out since that the UK government, the intelligence services engage in hacking, which were revealed in a variety of the different Snowden documents. We understand that they have engaged in the past and will continue to engage in the bulk collection of communications data both outside the UK and within the UK. So there's been quite a bit of confirmation at the more abstract level of what was released in the Snowden documents, even if it wasn't the particular operations or code words. Although, as I mentioned, there hasn't necessarily been confirmation of some of the real specifics of the program, besides the idea that bulk interception is taking place. What type of material? We know that it's content, and that's a very broad descriptor, but does that mean necessarily that all the video feeds are coming in and being analyzed? There's still some open questions along those lines. With regard to the UK framework on cooperation between the intelligence services, I think that there continue to be large questions about how that framework works because of the point that you just made, which is that it can be very difficult to effectively oversee them given the restrictions that other countries may place on the information that is being shared with the UK intelligence services. The framework in the UK right now is relatively sparse when it comes to intelligence sharing. We understand that it can be permitted under the Investigatory Powers Act, and we understand that in the fairly narrow circumstance of sharing between the US and the UK, as came out during our lawsuit, that the UK should be obtaining, if possible, a warrant-like authorization to obtain the data from the US. And again, I think Mr. King may be able to describe this in a bit more detail, but we do believe that there are actually quite large, and this feeds into the second question that was asked on this area, quite large databases that are being shared, at least between the Five Eyes and perhaps other governments, of data, essentially raw data that has been unprocessed or unfiltered, and that at least the US and the UK have access to those databases. And that what rules are applied during processing, it's not entirely clear from the national laws of either country as to how they can get access to that data.
I'm just trying to consolidate the questions to answer them in the most helpful way. Perhaps just taking them in order is simplest. The question was asked, why did the Five Eyes No Spy arrangement come into practice? I think we should be clear here about what the No Spy arrangement does. It doesn't prohibit targeting of each other's citizens. What it seems to provide is a process upon which you get authorization to target individuals. And in almost all circumstances, that's the appropriate course when we're talking about surveillance. It's not a prohibition of the practice of acquiring communications that may be necessary for preventing terrorism or pertain to an individual that threatens a country's national security, but it's what's the lawful process that regulates that to prevent abuse and to ensure that the targeting is done in an appropriate manner. The reason why the No Spy Pact, as it's dubbed, came into existence was, best I can ascertain, a matter of practicality. The Five Eyes signals intelligence agencies are so interlinked. Their staff sits next to each other. One officer told me at one point that the lunch pass at GCHQ gets you into the lunchroom at NSA. Such is the level of integration. And as a result, it's pretty obvious that it would be inappropriate to permit one officer to the left to do something that they would not be able to do. And so as such, they simply collaborated to say, look, while we're sitting in the same room, we need to put in place some restrictions to make sure that we can't be directly targeting each other's citizens, and it's grown from there. You asked whether people were targeted unlawfully. We have some information about that. Amnesty International were found by British courts to have had their communications unlawfully interfered with. Importantly, the court didn't find that it was unlawful for them to be targeted in the first instance, but internal procedures inside GCHQ were not followed. In this instance, it resulted in the fact that material was held for too long and selected inappropriately, and as such, the court found that that was unlawful. There are other circumstances where it hasn't gone to court, but I think you could test the lawfulness of it. Le Monde published an article, I think last week, perhaps the week before, where it described how GCHQ were targeting telecommunications companies across Europe. They were targeting technical staff at these companies. They were not national security threats, these staff. They were not committing any sort of serious crime. The reason they were targeted is because they hold privileged information, which GCHQ wanted, and once that information was acquired, it would allow them to hack or to target the communications of other people. Now, under British law, the agencies would say that that's lawful. It's lawful to target someone who's innocent, who's not a national security threat, nor is suspected of committing any crime, so long as they hold information that might be relevant to Britain. Now, for me, I find that deeply unsettling and not a practice that should be encouraged. The question was asked about the exchange of material. Again, as is often in this area, we don't have the full picture we would like. Privacy International requested updated versions of the Five Eyes intelligence sharing arrangement, sent out freedom of information requests in some circumstances, and has gone to court in others to try and obtain them. GCHQ's position at this point is that they apply in practice the same protections that they would to material received from a foreign partner as if they'd intercepted it themselves. I think that only begins to scratch the surface of how the arrangements actually work in practice. One of the clearer examples that I can provide you is the situation we have at the minute between the UK and the Dutch. The Dutch intelligence services are not allowed to tap undersea fibre optic cables, as I understand it. They're only allowed, their legislation only permits the interception of communications from satellites off the air, and they're strictly prohibited from tapping cables. So the question came up after the Snowden revelations is, could they receive information from foreign partners that they know to have come from these undersea cables that they themselves are prohibited from tapping? And the oversight body in this instance undertook a thematic review. It was a very detailed one, but they concluded that it would be impractical to try and put in place such a restriction because there would be no way to know what material has come from what source. You know, I can see how that argument can be made, but I don't think it acknowledges the reality of intelligence cooperation as it stands between long-standing partners. Certainly between NSA and GCHQ, they have a full understanding, for example, of which program works in what way. In many circumstances, they built the programs together. They built the technology together. And I imagine that there'll be areas where the same will be for Germany and Britain and the NSA in Germany as well, although perhaps not quite so comprehensively. The other area where it is controlled much more strictly is with finalized intelligence reporting. I think this is a legacy of how spying used to be done, which was mostly human intelligence, analyzing material and then providing that back. These days, as we all know, it's raw SIGINT collection. So there are better controls in place for the exchange of finalized intelligence reports, None of that applies to raw exchange of that raw material, and that's where protections need to go. Finally, to Mr. von Notz, the question about the practical ways that filters are applied within the no-spy arrangement. I'm afraid it's not at the collection stage, as you correctly assumed. Once collected, the material has to be processed in some way to determine what it is, and it's at that stage that material is deselected, or I think they call it a Five Eyes blind, which is that anything that they can identify coming from a British IP address or even a British organisation, and some of that is quite generously put, as I understand it, is then subtracted from the material as it continues to be processed or minimised, which in practical simply means that it's flagged such that it would require additional authorization to begin to look at it. Most of the protections then apply when a human searches for material relating to someone from inside the UK or pertaining to the Five Eyes. The reason for why safeguards have developed towards that latter end of the process, though, is because that's where our law and policy has constrained them up until this point. I am of the view that should a greater appreciation of the level of intrusion that occurs earlier on in the process, i.e. if intelligence agencies begin to acknowledge the level of invasion of privacy that occurs simply at the point of collection, then you would necessarily have to improve the level of technical protections that could be afforded at that point. I think that's addressed all the questions.
Ich hoffe. Ich gucke mal gerade in die Runde. Das ist der Fall. Dann beginnen wir mit der zweiten Runde.
Okay, so we can begin with our second round of questions.
Herr Kollege Schipanski.
Mr. Schipanski, please. Thank you, Chairman. Now, we heard experts here during our last meeting, and we spoke about the so-called circular exchange, and I would like to raise this issue once again, because so far no expert witness has confirmed to us that this circular exchange between intelligence services actually takes place. And you are the first to basically confirm that this circular exchange does take place. That the Five Eyes, in other words, exchange data, process data together. However, I have become somewhat skeptical after hearing that you, Mr. King, said that you had heard, and then you spoke about the lunchrooms of NSA and GCHQ. You were asked how the data are exchanged and processed, and of course you don't have any precise first-hand information on this. And Ms. Palow, you said that you believe there is an exchange of data, but of course you are here as experts today, and we would be interested in learning from you what you actually know about this. Whether you can tell us that you know there is a circular exchange. So is there any concrete evidence that you can give us here? Where do you get your findings from, your knowledge from? Because you are actually the first people here to confirm that the circular exchange is happening. Thank you very much. Mr. von Notz. No, Mr. Hahn next, please. Thank you very much, Chairman. Unlike the previous speaker, I have heard many times here in this room that there is a potential circular exchange taking place. But irrespective of this, I would like to follow up on something which was mentioned a number of times, data hacking, and you mentioned the fiber optic cables, the undersea cables. And I would like to ask you what you know about GCHQ's practice here concerning the surveillance, the tapping of these cables on the seabed, and how the UK services gain information through this method. So what is the precise information that you have concerning these practices? Thank you very much. Now the question is whether we have time for more questions, because we'll have to leave in a minute for our vote. So we'll give you the opportunity first to answer the two questions before we leave for our vote. Mr. King, please.
Perhaps I'm trying to perhaps you use the word circular exchange, or perhaps it holds a slightly different connotation to the one that we mean here. I mean, it's not contested by the British government that they exchange information with foreign partners at all. Indeed, all intelligence services practice it. It should be encouraged. In my view, there's absolutely nothing wrong with intelligence exchange, so long as it's authorized by law, properly done, and able to be overseen by the respective parliaments. The threats we face are global, and our intelligence agencies need to respond as such. Perhaps the narrower issue that you're asking is whether or not there are activities that exist between allied partners in which they attempt to circumvent the domestic laws of their own countries. Perhaps it's that point that is kind of sharper here. The way, an example of this, which I think is one of the clearer ones, is the fact that when the National Security Agency ran a program called Muscular, this was intercepting the cables between data centers of American companies, Google and Yahoo included. They didn't tap those cables in the United Kingdom. They didn't tap them in the United States. That's where the majority of the data servers are. They didn't tap them there. Instead, they asked GCHQ to tap them, and they were tapped between the UK and Ireland. I don't know why they did that. It doesn't make any sense to me, beyond the fact that there will have been political and policy reasons for why they will have asked a foreign partner to do something that I think would have been difficult for them to justify domestically. That's not an example of a breaking of law, necessarily. A court hasn't looked at that or ruled on that. But that's the sort of thing that I believe happens. If you'd like, I could give it more thought and perhaps prepare additional note, kind of pulling together every example with the fact that I'm able to kind of draw up, if that's a particular point of concern. The only other thing I would very briefly say, there's a fantastic old book called UK Eyes Alpha, which is British, which is written by the old BBC Foreign Service correspondent, and in it he interviews a number of Five Eyes officers. There's 3 quotes in there that I think paint an interesting picture. These aren't quotes I've acquired, they're in a published book, in which he describes the level of cooperation. He says, the national product between the Five Eyes arrangements is often indistinguishable. SIGINT customers in both capitals seldom know which country generated either the access or the product itself. Another one says, the cooperation between the two countries, particularly in SIGINT, is just so close that it becomes very difficult to know who is doing what. It's just organizational mess. Now, when you have agencies working so closely, but you don't have oversight bodies working as closely, you get into all sorts of problems. And I imagine you'll have seen evidence to this committee about the problem of treating oversight parties as third partners. That is, when intelligence agencies enter into exchange arrangements, they limit the exchange to only the agency that's receiving them and prohibit sharing to any other third party. In many circumstances, the further sharing of that to third parties would include making that material available to oversight bodies themselves. I don't know if that's a problem in Germany. I haven't looked at the examples here, but certainly it's a well-recognized international problem.
Ganz herzlichen Dank. Ich muss jetzt unterbrechen, weil wir zur namentlichen Abstimmung müssen.
I'm sorry, I have to interrupt at this point because we have to go to our roll call vote and we'll continue with the next statement afterwards. So the meeting is adjourned.
So, meine Damen und Herren, ich würde gern weitermachen. Also bitte in den Saal kommen und die Plätze einnehmen, dann geht es auch sofort los.
I'd like to ask you to
Ich hoffe, die Übersetzung ist auch wieder da.
be seated so we can continue. I hope you can hear the translation.
Sobald die Tür zu ist, geht's los.
And as soon as the door's closed, we'll continue.
So, meine Damen und Herren, die unterbrochene Sitzung.
Okay, ladies and gentlemen, the session is resumed and we will continue with the response by Ms. Wilson Palow. You have the floor.
Thank you. I would agree with what Mr. King has already said with regarding the circular exchange. It is true that we don't have many explicit examples of if what you mean by that is the violation, the sharing of information explicitly against UK law with, for instance, the UK government. But what we do have are evidence of, for instance, the raw unanalyzed sharing. And you can look back all the way to the public version of the Five Eyes Agreement, which dates from the late 1940s, early 1950s, and the type of information that is said in that agreement will be shared between the Five Eyes, and it includes this sort of unanalyzed data. And actually, in the course of our lawsuit, 10 human rights organizations versus the UK, which is currently pending at the European Court of Human Rights, we have gathered together quite a bit of information because the sharing between the US and UK is one of the questions in the lawsuit and what sort of safeguards and regulations surround that sharing. We have gathered together quite a bit of information surrounding that analyzed sharing and what safeguards are in place, and we'd also be happy to share the submissions that we have made there as well, if it would be helpful to the committee. With regard to how fiber optic undersea cables are intercepted, what precise information we have, there again, from my perspective, I would point to what we've learned in that particular lawsuit, because that has been discussing the bulk interception power in the UK. And again, the UK government has not been terribly forthcoming as to exactly how that bulk interception power works. But we do have some information that we've been able to glean from the Snowden documents and also from what has been admitted during the course of the lawsuit. We know that initially large amounts of information are obtained, and the UK government has been said that while they have a legal obligation ultimately to try to split what are called foreign communications, which are communications between the UK and abroad, or happening entirely abroad, which may be traveling over these cables, and communications that are entirely internal to the UK. They've said technically they're incapable of doing that. And that is one of the reasons that when they intercept these fiber optic cables, they pick out all of the communications at the same time. And then they will later apply a filtering process and later apply selectors, but that is much later down the line. What might initially be filtered out could be information that is thought to be not particularly helpful, like large video files or other information that's unlikely to contain the communications content that they're interested in. But then we know that potentially for quite a period of time, both the content and the communications data or the metadata associated with that content can be stored. And then selectors may later be applied, but within the UK at least, those selectors, when they're referring to those foreign communications, can be quite broad and don't require additional approval. Whereas it's only if they were to attempt to target someone who is believed to be located within the United Kingdom that additional protections apply. And that is true both under the previous legal regime and under the current Investigatory Powers Act. Aside from that, we have actually been able to learn a little bit about the bulk interception process from some of the reports coming out of the US, which I'm sure you're aware of, from particularly the Privacy and Civil Liberties Oversight Board, which has described the way in which the NSA conducts this bulk interception under Section 702 of the FISA Amendments Act, which in the US is often referred to as as one of the Snowden codenames is upstream for that program. And it seems to be a somewhat similar process, which is large unanalyzed amounts of data are first collected and selectors are applied at a later point. Thank you.
Ganz herzlichen Dank. Und jetzt kommen wir als erstes zu...
Thank you very much. Is there a follow-up question? No. During the interruption, we heard Mr. King speaking on the circular exchange, but my question concerning the subterranean, the undersea cables was directed to both experts. So maybe Mr. King could speak on the undersea cables.
An additional report that Caroline didn't mention as well is the US National Academy of Sciences report, which is a 300-page report that explains in pretty significant detail the process by which fiber optic cables are tapped, the material ingested, processed, and analyzed. My only criticism of a report of that report is that it is simplistic in its nature. This is in part because whereas 30 years ago the way that signals intelligence was collected followed a pretty straightforward route. That is, identifying what it is you're trying to collect, working out how to collect it, looking at the material you've then collected, processing it, and then matching it against what you were trying to collect, leading to a finalized intelligence report. That method was a perfectly satisfactory one when you were dealing with kind of concrete human intelligence, files, documents that you were trying to steal, that sort of thing. With signals intelligence, at the scale it's run today, that chain is essentially permanently looped, i.e. material once decided to be collected is got in bulk. When it's processed to determine more, to understand what information was acquired and then rematched against it. In the United Kingdom, there's a particular type of process called query-focused data sets that are created from this raw SIGINT. To the extent that your committee has analysed the equivalent here in Germany or in the US, I would suggest you focus on it in great detail. The importance of it, to my mind, is that query-focused data sets acquire large amounts of raw material. It processes them and ties them to identifiable individuals, essentially creating the modern version of a dossier on a person. Thus, when they are stored, even if they're never looked at by an intelligence officer, the level of intrusion is far greater than simply storing it in an unindexed form. It's much more akin to profiling, something that the European Court of Strasbourg and Luxembourg have both attached more significant importance to. And I think it's that area that probably requires much greater safeguards, and it's the area where our law has not done enough to acknowledge that change in technical capability in that way. I can speak a lot more about this issue, but perhaps I should stop there.
Gut, dann kommen wir jetzt zum...
Okay, then it's Mr. von Notz's turn. Thank you very much. I have two questions concerning your knowledge about Five Eyes activities in Germany or cooperation with the German Federal Intelligence Service, the BND. I'd like to ask this question as broadly as possible, maybe just two key words here. First of all, the T14 cable and potential cooperation in 2013, cooperation which was probably launched in 2013 between GCHQ and the German BND. Are you aware of individual operations Glorteig is the name of one operation which we have heard about. Do you have any further information or any knowledge concerning the role of the German BND, the Federal Intelligence Service, in cooperation with the Five Eyes and GCHQ in particular? Thank you very much. Okay, Mr. King. No, what was the order? No, it's the other way around. So it's you, Ms. Wilson Palow.
I may actually defer to Mr. King on this one. Because I'm afraid I do not have much more information than what we already know has been revealed by this committee.
I'm afraid, while I would love to answer that question in full, the extent of the knowledge that I have, I'm sure is shared by the committee here. I've read the Der Spiegel report and the codename, I think it was Monkey Shoulder. I have attempted to find out information in the UK about it, its relationship, how it was regulated, whether or not it was part of, whether it was simply bilateral, whether or not it was part of a broader set of undertakings which GCHQ might have been trying to establish also with the Dutch in a similar way, exchanging material. Similar sorts of programs are run by the NSA under the Rampart code name. I regret I haven't been able to obtain any further information from the British government. Of course, this is a point that's deeply frustrating. Our oversight reports in this area protect national security by not referencing specific code names. While that is, of course, proper in principle, it is frustrating when you're trying to understand the legal requirements and whether or not policy is being lawfully followed. We've had a number of oversight reports in the last 3 years, none of which clearly address this issue, despite efforts. I wish that wasn't the case, but that's where we are.
Okay, gut. Dann.
All right, next round of questions then. Mr. Schipanski, Mr. von Notz, Mr. Fliesek. Okay, Mr. King, let me jump into what you said before. You were a little more specific with the circular exchange. We do mean by that the circumvention of national legislation to acquire information, yes. So, against this background, and you're here as an expert, how do you know this? You quoted books. Did you speak to members of the intelligence services? Is it the result of research? Did you get it from newspapers? You mentioned the Spiegel report. It's just important for us to get an understanding as to where you got your information. And the second question, Ms. Palow, you mentioned the Snowden documents as a form of proof a number of times. Within our work here in this committee, we were unable to actually establish whether the Snowden documents are actually genuine and what their importance would be. We showed the documents to a number of witnesses, and some said, well, actually it's technically not possible what Snowden described in the documents. So how did you actually establish the authenticity of the documents? Mr. Hahn, please.
Nein, bitte unterlassen Sie
Be quiet.
Zwischenrufe. Nein. Ich würde jetzt sofort die Sitzung unterbrechen.
No, I mean we can interrupt right away. Okay, we interrupt now. I'm sorry, we have to interrupt for a brief consultative meeting. Please, everybody leave the room. Also, our experts, please leave the room. We have to sort this out internally. Thank you.
So, meine Damen und Herren, wir setzen die unterbrochene Sitzung des ersten Untersuchungsausschusses
All right, ladies
fort.
and gentlemen, we
Die Vorweihnachtszeit hat schnellen Frieden gebracht.
our meeting. Peace has been restored. And
Die nächste Frage vom Kollegen
we move on to the next question. Mr. von Notz, please.
noch die offenen Fragen.
And then we finish off with the open questions, Mr. Fliesek, Ms. Renner, and then you get the chance to answer. Right, I would just like to get back to the term metadata-centered collection. Not the metadata collection, but metadata-centered collection. What does it actually mean? What is it? Mr. Fliesek? One question I'd like to add before the European Court of Human Rights. There are 3 pending cases by British NGOs, and this question is not addressed to anyone in specific. Whoever would like to take this up, please give an answer. And could you also tell us what it is about and what the status quo of these cases is? That would be helpful for us. Thank you. And Ms. Renner? A somewhat more specific question. In this committee, we also looked into the cooperation of German services with the DIA in the interrogation of refugees that arrived in Germany. Are you aware of such a cooperation with the British intelligence services? That is to say, whether British intelligence services actually interrogate refugees here in Germany without them actually knowing who the person was that questioned them? Thank you. All right, Mr. King, your turn is yours.
I'm afraid I might need some clarification on your question, Ms. von Lutz. I don't think I'm familiar with the term metadata-centered collection, but perhaps it's a translation error. Is there? Could you ask the question a different way? Perhaps I can better understand.
Auf die Nachfrage gerne.
Sure. Well, it was common to go through large amounts of data with selectors and personal identifiers. Today, and I think I hope I understood this correctly, there are certain parameters, certain behavioral patterns that are used. So, and this is what you use in order to filter through the data. Who switches the phone on at what point in time, who changes SIM cards, who calls the same number of people time and again. So things like that. So this is basically a new approach, if you will. And SIGINT is taking over these sectors as well. And what does that mean for the data that is collected, the raw data that is collected, where you can use these new patterns to filter through these data? That's what I meant. But if you don't know, that's fine. No problem.
I mean, I can speak to that. I mean, certainly the way that signals intelligence works today is, as you describe, is to focus on metadata. That's for practical reasons. For a long time in the United Kingdom, our protections were provided to the content of communications rather than to the metadata. There were significantly reduced protections for metadata. Remarkably, our oversight bodies in the United Kingdom didn't understand, actually, that the metadata was the more important aspect for signals intelligence agencies.
Same thing here.
And to their credit, the oversight body acknowledged that in their report 2 years ago. They said, we were surprised to learn after talking to the intelligence agencies how important metadata is to the collections of signals intelligence. There's a variety of ways in which you can understand the importance. In the US, former directors of the NSA, have boasted about how important metadata is. I believe the former director of NSA boasted that they kill people on the basis of metadata alone. Stuart Baker, the former general counsel of NSA, has also said metadata tells you all you need to know about anybody. And it's for obvious reasons. It's because very often the fact of a communication is much more important than the content of it, particularly when you're trying to analyze material of thousands, hundreds of thousands, millions of people. It's a structured way of achieving those goals. I don't expect that to decrease in the future. In fact, with the rise of transit-based encryption, the content of communications are likely to be more protected in future, resulting in a push by signals intelligence agencies to focus even harder on the acquisition and analysis of metadata.
Okay, die weiteren Fragen?
Sorry, I might just add to that in the case currently pending before the European Court of Justice, the case of, it's both the referral from Sweden and from the United Kingdom. The United Kingdom case is Watson and others versus the United Kingdom regarding data retention. There's actually quite an interesting passage from the Advocate General in that case describing the ways in which metadata can be used and very helpful in this regard. And he describes how it is quite a useful tool for looking very quickly at large populations, being able to discern patterns in the exact way that you just described. Maybe I'll just briefly address the question regarding the 3 cases currently pending before the European Court of Human Rights. I think you may be mentioning that they're the 3 cases that are joined together. Yes, one of which is the 10 human rights organizations, which I mentioned earlier, in which Privacy International is a claimant, along with Liberty, Ms. Carlos from Liberty, you heard earlier, Amnesty International, and 7 other NGOs, along with another related case, which is Big Brother Watch, Open Rights Group, and several other UK NGOs, and then finally a third related case, but they're all dealing with the same general issues, which are 2. One is the question of whether or not the bulk interception regime in the United Kingdom is lawful under the European Convention on Human Rights. And the second is whether or not the sharing of information between the US and the United Kingdom was lawful under the legal regime that was in place in the United Kingdom at the time that occurred. And so that case, at the moment, observations have been submitted by the United Kingdom, and we have, the claimants have responded to them, and then we are waiting for the next phase of the case.
Okay, ich sehe jetzt alle Fragen noch nicht beantwortet. Ich glaube, Herr King hatte noch eine.
Mr. King, the answer to Mr. Szymanski's question and Mrs. Renner's question hasn't been answered either, so whoever wants to reply to those questions.
I'm not familiar with news relating to that. I apologize. And Mr. Szymanski's question, was that the one asking where I get my information from? So I'm an academic at this topic at the moment. I teach a law course in the United Kingdom looking at intelligence collection and surveillance as it applies to law. I've spent the last 7 years looking exclusively at this issue of signals intelligence. My sources are varied, as they are in all research. That's oversight reports provided by governments, that's speaking with law enforcement bodies, former intelligence officers, former lawyers at intelligence agencies, government departments, our Home Office, and others that have looked at this. Leaks material from Snowden and from a wide variety of other sources, some of which are confirmed to individuals, some of which are not. Autobiographies and biographies from former intelligence officers. Academic studies written in collaboration with intelligence bodies, international organizations reports on oversight from the Council of Europe and others who have work with intelligence officers. So the the broad spectrum of material, and so I based my analysis of my research using that sort of material, if that's helpful.
Okay. Gut, und Frau Kollegin Renner?
Thank you. Ms. Renner's question, sorry, there was no answer to that question.
Letzten Frage, oder geht's schon wieder eine neue Runde?
Mr. von Notz, is that a new round or what? No?
Das ist eine neue Runde.
Okay, there is a new round. Yes, Mr. von Notz.
Genau. Ich wollte vielleicht noch einmal nachhaken.
Just one question relating to this issue of metadata, which we just covered. In this committee, we deal very intensively with the question of selectors. And I would say it's kind of an outdated practice, but it is still used in order to sift through large amounts of metadata. And you may have followed our proceedings in the media. The BND here in Germany actually developed a large number of selectors that they control, and we dealt with the question of admissibility and things like that. But the BND also controlled millions of selectors on behalf of NSA for a number of years. So selectors, is that an issue in the UK? And if so, how does parliamentary oversight work in the case of these selectors? Is there a debate what they are allowed to control, what they are not allowed to control? Are there any taboos for journalists, for example, or are there certain periods of time where you are allowed to use selectors for a certain period of time, or do the services just do whatever they want? Ms. Renner, and then I think we're kind of running out of time. Ms. Renner?
Klar, wenn wir dann die letzte Runde schaffen, dann denken wir am besten.
Dann ist meine letzte Frage.
Okay, so no, I have another question, one last question. The TAT-14 cable. What is happening there? What does the British service do with this fiber cable that holds European data traffic? Are there any indicators? I know probably no one knows exactly, but we have an idea what's going on there, so maybe you could add some information when we look at this fiber optics and the interception of fiber optics cable on this cable. What is actually taking place on the cable, especially the TAT-14? Thank you, Ms. Renner. I guess two questions. We hear from government sources that if we get into too much detail regarding certain operations by the intelligence services and the cooperation of intelligence services, this could lead to a lot of displeasure on the other side, so that they might question the cooperation as a whole. So, your knowledge about GCHQ, Mr. King, do you think this is realistic, that they would actually cancel any sort of cooperation if we ask too many questions? That is what I'm saying. Do you think this would be a realistic behavior for them? And secondly, Ms. Palow, I think you're the right person to answer this question. What rights do non-UK citizens have when it comes to data gathering by British services in the UK? So basically, who can is there a way for people to ask whether they were subject to surveillance, what kind of data were gathered, and who is entitled to ask these questions or demand that their data being deleted? Is there like equal treatment for EU citizens and UK citizens and citizens of other states, or are there certain rights that only UK citizens have? Thank you. That covers our questions. Please, Ms. Wilson, if you would like to start answering these questions.
Yes, thank you. With regard to the question on selectors and oversight, and I'm sure Mr. King will have more to say on this as well, but in the UK, the specific question of selectors and how those will be used was not something that's specifically addressed in the Investigatory Powers Act. there are now a new scheme of broad authorizations for different types of interception, and a relatively new scheme of having an additional judicial commissioner who will sign off on the warrants. But selectors are never specifically mentioned. There are also certain protections. They may not go far enough, but there are certain protections for groups like journalists, legally privileged material, members of parliament. But again, there's no specific mention of selectors in that process. That's something that we certainly brought up during the course of the debate as an area where safeguards might actually be useful to be applied. But ultimately, that's not something that's specifically mentioned in the law. With regard to what rights do non-UK citizens have in the United Kingdom, it's not so much based on citizenship, but on location. So anyone who's located this is what the Investigatory Powers Tribunal, the oversight body of the UK Intelligence Services, has said. Anyone who's located within the United Kingdom and can take a claim to the Investigatory Powers Tribunal, requesting that there be an assessment of whether or not they were unlawfully subject to surveillance. Until recently, it seemed apparent that anyone around the world could come to the Investigatory Powers Tribunal, but there was a decision this year that said where the tribunal said only those people within the UK have rights to bring those claims under the European Convention of Human Rights. So I should be specific about that. So the tribunal has said that anything under the European Convention of Human Rights, they only have jurisdiction to hear those claims if it's about someone who's located in the UK at the time the claim occurred. If it is a violation of UK law, it is still possible for anyone to come to that tribunal and allege a violation of UK law in the course of the surveillance.
To take questions in turn, dealing with TAT 14, I'm afraid I'd have to look back at my notes. I recall that there were a number of publications relating to specific cables that were being intercepted by GCHQ, and the percentage of egress, that is, the percentage that was taken in from the cable, was published, as well as projections for how that would grow over multiple years. I'm afraid the list was very long, and I can't remember TAT 14 specifically within that. One of the takeaways of that publication was that I did note, however, was that over the course of 4 years, GCHQ's capability to intercept from undersea fibre optic cables increased by 7,000%. I make this point because when we talk about our statutory framework regulating this, concepts of necessity and proportionality become essentially tied to technical capability. And they are pushed to their limit, in my view, when you can have a 7,000% increase in an activity over 4 years and not need to change the statutory framework limiting collection. This was in 2009. I imagine it's increased from this point. I think at around that time, GCHQ had the ability to intercept from almost all cables coming into the UK. But in practice, in 2009 at least, and this is dated information, they were collecting off about a quarter of those at any one time. In terms of limits on selection, as Caroline explained, there's nothing in our statutory framework that regulates the selection of material. I think this is clearly problematic, as it doesn't reflect how intelligence officers do their job. We almost have a completely separate legal framework and a completely separate set of rules to what the day-to-day activity of an officer is. My view is that our laws should be drafted to reflect what it is that our officers do and the collections systems that take place. What we do know from the Intelligence and Security Committee, and this is in their public reports, that Britain has 2 separate collection systems. The first is a major processing system targeted at bearers, as we call them in the United Kingdom, these undersea fibre optic cables. The system compares the traffic against a list of simple selectors. That's a term we use in the UK. I don't know if it's the same here. These are specific identifiers relating to a known target. Any communications which match these are collected. So that's one major processing system. From there, there's a triage process. But there's another major processing system which isn't called tempora in the official documents, but is widely understood in the United Kingdom to be tempora. And in this instance, it says that bearers make up the internet. GCHQ applies selection rules. And as a result, the processing system begins to sift through that material. Now, the distinction between those two is quite important. The first is a simple selector, which is about a known target, that is your email address, my phone number, something of that nature. And the second processing system is a selection of rules. That is a string, a number of different variables put together. This is what you would otherwise call trawling for information, not tied to a known specific individual. And it's that second processing system that I think is much more problematic. Ms. Renner asked about whether or not it's likely that an intelligence agency would stop sharing material. I think it would be quite short-sighted of any agency to break entirely contact with another service. Certainly, Britain has relationships, with hundreds of different countries. I think in the last evidence session from UK experts, a number of 168 was provided, I think, by Mr. Anderson. In my experience, there's only one circumstance that I can think of amongst allies and where that stopped happening, and that was when New Zealand was nuclear-free. This was in the late 70s, early 80s, and had a very strong policy position which prevented American nuclear power ships from landing in New Zealand waters. And the dispute was so significant that they did stop sharing material, I think, for a period of 6 months. Soon after that, it picked up again and resumed. There is, however, two quotes that I'd like to provide to you, which I think provide a bit of a picture about how intelligence agencies see their intelligence sharing relationships. The first is a NSA Foreign Affairs Directorate leaked document. They say, for a variety of reasons, our intelligence relationships are rarely disrupted by foreign political perturbations, international or domestic. In many of our foreign partners' capitals, few senior officials outside of their defense intelligence apparatus are witting to any SIGINT connection to the US. In another story that was published by Signal magazine, which is a signals intelligence magazine in the US, Admiral Michael Rogers said, clearly we have some nations that have been very vocal, very visible in their frustration and their unhappiness. He goes on to say, but we have a level of capability and a reach that literally few, if any, can replicate. The value that NSA in this instance provides them in terms of information that we share is almost irreplaceable. My view of looking at those together suggests that intelligence sharing is a practice that will survive almost all political disruptions. I hope that's of assistance.
Good. Okay. There are no further questions, no further remarks. This brings us to the end of this part of our hearing. Like I said at the beginning, once the minutes are finished, they will be forwarded to you. And you will have 2 weeks for any corrections or any amendments, should this be necessary, and then return the record to us. Again, we learned a lot from this hearing, and together with the other information that we gathered, we will put it in context. But I believe that the view towards the UK shows us a lot, because at the beginning we focused on the United States a lot, but what we learned from the UK about the activities that take place there, let me word this carefully, it deserves our observation. You supported us in this attitude, and thank you very much for this. And what I just heard, we are still in the same legal realm, so to speak, within Europe, and this might help us in finding a good approach regarding the legislation for data retention to find a good and solid basis for the protection of privacy as far as the work of intelligence services is concerned. Thank you for being with us. Thank you for coming here. Thank you for answering all our questions. Safe travels. Thank you.